webinar. I hope
Yeah,
all
thanks. Thanks, Vivek and Vinay, for this opportunity. Yeah.
I'm sure all the attendees and Vinay and I will learn a lot from this session today. So I see people are still joining. Give it 1 more minute and we'll start at 3 or 4. Fun fact for while we are waiting for everybody, Ankur and I actually belong to the same city, Agra, but we had never met. We didn't know each other. Common friend of ours, we met him at an ICANN meeting, and he made the connection that we both belong to the same city and introduced us. And since then, Ankur and I have worked together on multiple ideas, and we regularly consult with Ankur on a lot of cases that we work regarding online brand protection. Okay, so it's 3 or 4. Vinay, I think we'll get started. Okay.
Yeah, I think let's do that.
Okay, cool. So thank you everybody for joining our session today. We have termed it in a non-technical way so that it's easy to understand as well as easy to grasp, and there is some solid learning for everybody on what not to do in a UDRP or an INDRP. So quick housekeeping rules. We have scheduled this webinar for 60 minutes, but we will wrap up our discussion in 40 and then we'll leave 20 minutes for Q&A. While we are having the discussion and going through different cases, please feel free to add your questions to the chat window, and Vinay will at the end collate all these questions and ask us. We will record this presentation. The recording is on, and both the recording and presentation will be made available to all those people who have registered for the webinar. Quick intro. We are purely an online brand protection company. We are not a cybersecurity company. We provide services such as brand monitoring, digital brand enforcement, domain acquisitions and management, new branding consulting, and rights protection mechanisms such as TMCH, URS, INDRP, UDRP, and others. So today, as the webinar title says, what not to do in a UDRP, we'll be talking specifically about INDRP and UDRP. Some of the clients we serve in India are Sarva, Himalaya Wellness, Snapdeal, Swiggy, Kama Ayurveda, India 1ATM, Naukri.com, and Byju's Features. Vinay has already kindly introduced me as well as Ankur, so I'm going to skip these two. And for those, I know there was a lot of students had registered for this webinar. So for their interest and for those who might not be so familiar with the terminology we use, I have created a simple slide to help you understand that in a UDRP or an INDRP starts with a complainant. It is generally the trademark holder or the company owner who actually files a complaint with an arbitration forum. For example, WIPO is a very popular arbitration forum, and it is the whole procedure is then governed by a panelist. So panelist is akin to a judge, but not really a judge, but the person who will actually decide which way, whether the complaint is granted the request or not. And then the person who actually owns the domain against whom the complaint has been made is called the respondent or the domain owner. So please keep this in mind, and as we discuss, it will help you when we use this terminology to figure out whom we are talking about. Now, domain name dispute by itself is a summary judgment. It is specifically provided for domain names, and it is mandated by ICANN. All TLDs under ICANN except CCTLDs follow the procedures set in by ICANN under the domain name dispute. It provides domain owners, it provides the trademark owners a quick resolution as compared to a lengthy legal process. So all TLDs have some form or the other of a domain name dispute process. Non-CCTLDs like the .coms, .net, the .orgs, and about 40 CCTLDs follow the UDRP procedures. Some of them also follow URS, which will be a topic for some other webinar. And under UDRP can be filed with multiple companies which have been approved by ICANN, one of them being WIPO, another one being National Arbitration Board. For CCTLDs such as .in, they follow their own process. They have set in either the CCTLD participates in a UDRP or they have set in their own procedures to manage domain arbitration and domain disputes. So for example, for .eu domain, adr.eu is one channel. For .in, which is the CCTLD for India, which is managed by NIXI, INDRP is the way to go if you have a dispute against a domain. I will hand it over to Ankur, who is a champion in this and will take us through how a UDRP works and also take us through cases which will explain us what not to do in a UDRP. So Ankur, again, thank you and welcome to the webinar.
Yeah, thanks Vivek, and good afternoon all. So coming to the three tenets of DND, so as Vivek already explained that the UDRP is basically a summary process, and the main purpose is to go after any domain name that may be involved in cyber squatting. Even in many UDRP and INDRP decision, you may find that the panelists will write down that we can't go into much more detail of the matter because such matters can be better dealt with a court. So that's why there is very limited conditions. Those are called the three clauses that needs to be satisfied by the trademark owner under either the UDRP or INDRP. First of them is that the domain name is identical or confusingly similar to the trademark or a service mark in which the trademark owner has rights. And the first clause mostly ends up with a simple comparison. Then the second one is that the domain owner has no rights or legitimate interest in the domain name. To take a simple example, a domain owner still may have legitimate interest, right? Say he is known by the domain name, exactly the mark that the trademark owner has, maybe it is the name of a person as well. And the third clause is the bad faith. So there's a little difference between what UDRP says and what INDRP says. So under UDRP, you need to prove as a trademark owner that it has been registered and used in bad faith both. While under INDRP, the complainant can prove either it is registered in bad faith or is used in bad faith. So if either of the condition is satisfied, so he can be successful under the clause 3. So now coming to the next part. So we have picked up few cases that will serve as an example for you to better understand the clauses. So coming to the first matter, it is under the first clause, identical or confusingly similar. So the most important part to understand is if you are coming under this process of UDRP, INDRP, it's a standing requirement, also most basic requirement that you should have a registered trademark. Or even suppose you do not have a registered trademark, at least you will be able to prove common law rights in the mark. So how the common law rights are proved? If you have evidence as to sales or say advertising under the mark, public recognition, or otherwise consumer surveys are there, or such evidence you can produce, then you can still prevail and come under the UDRP. So under this first matter, exactly the same thing happened. The Machani group that is based in Bangalore, they came under UDRP without having any trademarks. There was no registered trademark, but they claimed they have common law rights in the mark since the year 1950 or 55 something. And in 1954 itself, their founder was awarded Padam Shri by then Government of India. So they claimed they have been continuously using Machani mark since 1950s. But otherwise, there was no as such evidence as to use of their mark in commercial sense, but rather they had formed some companies which use the first name of the founder Somappa rather than Machani. But otherwise, evidence was rather more related to the year 2010 and onwards. Now coming to the domain owner is based in USA. He is staying there since 1997 and he registered this domain name machani.com in the year 1999 to match his last name. So the main issue here was that here the respondent, that is the domain owner, was otherwise known by the domain name. So given the facts that otherwise also there was no trademark registration and even the Machani group was not even able to prove the common law rights, but otherwise that they cannot even prove lack of legitimate interest or even bad faith against a person who is known by the domain name. So coming to the second one. Yeah, so second one is related to the domain name carefix.com. In this matter, a Danish company that is from Denmark that deals in surgical garments that came up after this domain name. So as you can see from the screenshot that the domain name was not as such in use but was put up on sale by a domain name investor. So the company claimed that firstly the company claimed that they have trademark rights since the year 1994-95 when they first applied for marks before USPTO and few European countries including Denmark. But they did not specify that all those initial trademarks had lapsed or expired in the year 2004 or by maximum 2006. And this domain name carefix.com was registered by the domain owner in the year 2008. So as a result, yeah, and additionally, this company, when they came to UDRP, yeah, though previous trademarks had lapsed, but still they had new trademarks applied before in various jurisdictions, but those were only 2009 or 2010 onwards. As a result, the date on which the domain name was registered, they had no valid trademark on record of any trademark registry in any part of the world. So here where they failed, because you need to have at least, though for the first clause, you can still satisfy the first clause if you have a recent trademark, but they cannot in any case prove that the domain owner registered the trademark in bad faith, because by that time when the domain name was registered, they had no trademarks.
Ankur, it's very interesting, these two cases, because one thing we have learned, having gone through a lot of UDRP cases and worked with a lot of clients, and we always tell them that do not hide facts from the panelist. If you have a gap in your trademarks and that's when the domain was registered, please make sure you convey it in the right manner to the panelist. Because one thing panelists hate the most is that somebody trying to dupe them, the complainant not giving them the full picture or not giving the full truth, and they really don't like it, and generally does not end well in the favor of the complainant. So in both the cases, we saw that in one case they did not have a trademark, in the other one they did not have an active trademark when the domain was registered. And time again we have seen this, where matters such as this could have been sorted with a simple financial transaction, but instead a UDRP is filed, and then the chances of acquiring a domain at a reasonable price further goes down. So, Ankur, very relevant cases. So let's look at the second tenet and see what examples you have to share. Rights or legitimate interest, Ankur.
Yeah. So under the second clause of the policy, that is here the burden of proof is more on the trademark owner, that is the complainant, to prove that the domain owner lacks rights or legitimate interest. So here they need to make a prima facie case in order to be successful under this clause. And in case the other party does not come forward, then if a prima facie case is made out, so this clause will always be held in favor of the trademark holder. So in this matter, the first matter, that is tatas.com, that is a little typo of the trademark Tata. So Tata Sons came with this UDRP against a Sri Lankan based company, tatas.com. So as you can see from the screenshot, there was a legitimate website on this domain name, and this company was dealing in some food product that mostly fall under class 30 of the Trademark Act. And surprisingly, Tata was having few trademark registration in Sri Lanka, but none under the class 30. Or otherwise, they are having some projects as to Tata Housing, tea plantation in the past were there, and Tata Motors is active there. Tata Motors.lk active website is there. But on the other hand, these Tata's people, they had already incorporated a company by exact word Tata's Global Private Limited since 2017, and also another additional company in 2020. So this domain name was just registered in 2020, and the UDRP happened only, you can say, after a year or so in mid 2021. So here the main defense was that there are a few sub clauses under this rights or legitimate interest. One of them is a demonstrable preparation to make use of the domain name. So if the domain holder is able to show that some preparation has already been done as to the use of the domain name, then it goes in his favor. But such preparation should be bona fide, and it should be visible because many documents like invoices were there, and also they had registration with the Sri Lankan Excise Department. So many such things were there that could prove that yes, demonstrable preparations have been done. And also secondly, they were known by the domain name and as also incorporated a company in Sri Lanka. So that's why the domain name was saved. So coming to the second part.
Just before you move, I think there is some strain with Tatas where they either file UDRPs which are not supposed to be filed, or they have bad luck with UDRPs. So Tata Motors also launched a car called Harrier, right? And they went and filed a UDRP against the owner who owned Harrier.com. Now, Harrier.com was registered way back in 97, 98, and Tata Motors launched the car Tata Harrier some time back. And I mean, if any UDRP lawyer would have told them that this will not work, but they went ahead, filed the UDRP and got shot down. So it is very surprising, and it does not matter how big your brand name is, how popular your trademark is. You need to be very clear that UDRP is decided based on these three tenets, and you should fulfill all these three tenets to be successful in a UDRP case. Could please share your views about Vogue?
Yeah. So coming to the next part, that is the domain name VogueTravels.com. So here, as you all are aware, Vogue is a very famous and well-known mark of the advanced magazine publisher company that is based in US, and they have many publications under their name. Vogue is one of them. The first trademark dates back to here somewhere in 1919, I suppose, and they came under this UDRP claiming that, as you can see on the screenshot, that there was no website active in the year 2021 then when this matter was filed. So they claimed that it was a case of passive holding and no use has been made, and by the year 2020 they already have such a well-known and famous trademark. So anyone trying to use a name like Vogue in a domain name, that will always be assumed as in bad faith. But in this matter, as coming to the respondent side, it is a traveling agency in Delhi. They formed as a partnership firm by the name of Mercedes Vogue Travels and also registered themselves with registrar of partnership in the year 2005 itself. And within 2 months of the registration of the partnership firm, this domain name was registered. Now the reason given for the registration of the domain name was that Vogue is a dictionary word, and of course it is. So, second point was that Vogue officially was launched in India, Vogue magazine, and they even incorporated an Indian company in the year 2007. So the initial evidence that they provided, though they tried to provide too much of evidence, but still it was not worth it that they can prove that the person who is operating as a travel agency where no services or any kind of goods are being sold under that class by the Vogue company. So it was a quite safe bet for VogueTravels.com. And from the year 2006 till 2019 or early to 2020 till the period COVID started, the traveling agency was very much active and providing services to many Indians and foreign nationals. Lot of evidence was available that they actively provided services and there was no as such prima facie violation of the rights of the trademark holder. So hence they were able to save the domain name. It went in their favor.
I think, Ankur, maybe you can speak a little bit about how the panelists consider the fact that a company which started in 2006, 2007 in India waited up till 2020, 2021 to file a UDRP against a domain. Do you think that lack of consideration earlier and waiting for so long is a positive or a negative, or is it neutral? It does not matter.
Yeah, I must say it always goes against the company because the thing is you should monitor your domain name or trademark. A company who is owning very such a strong trademarks that should monitor the domain names on a regular basis and go after any domain name that is infringing their right. Because though it is rarely held that that is latches has happened if you come to the UDRP after many years, but in many cases the domain owner, if he is not able to provide the evidence for the that goes back to the year say 2005 or 2006, he will always try to give such excuses that yes, we now cannot produce any such evidence that may help us, so it should be declared as time barred.
Thank you, Ankur. I think what you said is very valid, that constantly monitoring for domain abuse of your brand and trademarks is very important so that you can take action in the timely manner. Okay. Ankur, the third tenet, koi box.
Yeah, this is the very important one because whenever a trademark owner feels that some domain name has been registered, so the foremost thing is bad faith. Because in many cases, even if other party is it visible that maybe it may be having some legitimate interest, but it is not prima facie clear. But if bad faith is evident, then the panelist will go in holding against the legitimate interest as well. So here, coming to the first matter, it was regarding koibox.com. So in this matter, the complainant is a Koibox software company based in Spain. They came up after this domain name, which was being redirected to this Instagram page. Now, as such, there was no such violation that was visible, but they claim that it is just a passive holding of the domain name and no active use is being made. So they have held up this domain name only to sell this domain name to the trademark owner. Yes, because this software company also tried to contact this domain owner in trying to buy the domain name, but they failed as the domain name owner quoted some price that was not acceptable to them. So they came under UDRP. But the most unfortunate part was that this domain name koibox.com was registered in the year 1999 and the ownership was the same. It was the same owner, while this Spanish company came into existing in the year 2014 or 15, and they even had applied for the trademarks in the almost the same time. So in such cases, when the complainant will always miserably fail because a person who has registered the domain name in the year 1999, he cannot anticipate anything or any mark that may get registered or any company that may come into existence in any time in future. So it really went against the trademark owner because of the same reason. So coming to the second part, So it was a matter under INDRP policy. As you can see, it is a enow.in domain name. So what for this, complainant need to make a complaint before NICSI under the INDRP policy. So in this matter, the complainant, as you can see, the logo was Bennett Coleman and Company. That is the famous Times Group that have TV channels and newspaper, Times of India, Times Now, all such things. So their main claim was that they launched a TV program by the name of eNow in the year 2008. While this domain name had the registration date of 2010, and as you can see on in the screen, that screenshot, it was this is a screenshot of other website of the same domain owner. It is their corporate website serve.com, sarv.com. So basically the domain name enow.in was not visible as being used by them actively, but was only being redirected to the corporate website. So there, the claim of the Times Group was that the domain owner uh, should have knowledge of their trademark. Okay, one more point here. They did not have exactly the trademark over the term now, it was still pending, but they had some different trademarks, like for even now as a figurative mark, or Times Now, Movies Now, Romedy Now, they have a family of trademarks on now. So on the basis of that, they claimed that any person in India is supposed to know the well-known family of marks that is owned by the Times Group. But on the other hand, this the Serve company was using this domain name in a legitimate purpose. And there was no bad faith visible, because in the background, this domain name was used for having allocation of IP addresses from NICSI for the services related to servers that they were rendering to many famous Indian companies. The most famous insurance, banks, and political party, all are their clients whose emails are relayed through these servers. So even in case of any cybercrime or anything, all these email addresses ending with enow.in are being used for inquiry by any investigation agency. So all such things help the enow company to save the domain name.
Brilliant, Ankur. I think, again, I want to reiterate the fact that irrespective of how strong your brand name is, how popular you might be, you should do your due diligence before you file a UDRP. And I would also like to inform all the participants that all the cases that we have shown till now, Ankur has represented the domain owner and has won these cases. So he went up against Vogue, Tata's, Times Group, and won the cases for the domain owners. It's a real David versus Goliath story, where you don't care how big the company is. If they have not done the homework, if they have come unprepared, then there's a high chance that they will lose the complaint in the UDRP. Another thing I would like to point out that the cases that we have taken are not a true representation of the cases that come into UDRP. About 94% of the cases in a UDRP are always found in the favor of the complainant, which is the trademark owner. But our point here was to showcase that even companies with such strong trademarks, in some cases, or strong cases, do fall and do not win the UDRP. Another thing you should keep in mind is that sometimes it is much easier to buy a domain name than to go through the whole process of UDRP. The amount of time, money, and effort that a company will invest in filing and fighting a UDRP, where there's a chance of failure, could have been saved if they had actually gone ahead and tried to buy the domain name from the domain owner. Just as in case of Oilbox, one thing panelists don't like is incomplete truth. And we have seen a lot of cases where panelists were not informed that first the company tried to buy the domain name, and then when that failed, that they went ahead and filed a UDRP. Those UDRPs mostly are always found in the favor of the domain owner and not the complainant. There's a very specific case of failing where a complainant fails and is found to be RDNH, which is reverse domain name hijacking. So Ankur, quickly, maybe just take the Puma case and explain what is RDNH?
Yeah. So basically, reverse domain name hijacking is held against the domain name owner, and it's really a very strict judgment. You can say strict decision against the trademark owner. Mostly, it is held when it can be proved by the domain owner that the complainant has come to the UDRP with an intention to harass the domain owner without any solid ground or any uh, to take an example of the first matter, in the Puma matter, as you can see from the screenshot, it is very clearly mentioned that it's an incorporated company in India and the name reads as Puma Exports Private Limited. So Puma, the German company, the famous company, came under UDRP through an Indian lawyer. Now, when you are coming through an Indian lawyer, still you are again assumed to know that you know which companies are registered in India and what rights they may have. So this company had a history of registration since the year 1990, though the domain was registered in 1998. So in such a prima facie case, when the lawyer for the complainant is making statement, many misleading statement, so panelists very clearly noted down, you can read the judgment, that I understand you are a multinational company, you have a right to enforce your IPR against anyone, but you should not indulge in filing such a misleading complaint. This was the reasoning given for this RDNH judgment, and there were many, at least 10 different sentences that had been quoted by the panelists in the decision itself, because they really try to misrepresent the fact in order to gain control of the domain name. So,
Thank you.
yeah.
Ankur, maybe we can skip the tickets one, and if the time permits, we'll come back again. We have
Fine.
one more interesting case to discuss before we open it up for question and answers. The reason Ankur and I decided to put that case in, because on the face of it, they had everything correct, the complainant. They had everything correct. If you had asked me, will they win it, I would have said 99.9% chance you will win this case. But still they failed, and there was only one reason for that, and that was insufficient representation. The person who represented that somewhere lacked in the complainant, and I think Ankur will be best to talk more about this.
So this is a matter regarding KalyanJewellers.com. As you all must be aware, that Kalyan Jewellers is a well-known trademark in India, and they have presence since the year early 1990s, we can say, and they even applied for their first trademark around the same time, but they got their first registration of the trademark in the year 2003. And even the domain name registration was registered later, and otherwise there was no website on the domain name, like that is, it was a passive holding of the domain name for the last 15-16 years when this matter was filed in 2020. And also coupled with, there was false whois information, and as in many UDRP cases, it is assumed that if someone is providing wrong or incomplete or false whois information, so that means he is trying to hide something. So all factors were in favor of Kalyan Jewellers, and they did provide all the facts related to them, the company details, the history, the brand ambassador, all the images of the advertisement that includes Sri Amitabh Bachchan and all the celebrities. But still they were not were successful, though they could prove that they had trademark rights. Secondly, they could prove there was lack of legitimate interest because there was no website, neither the domain owner was known by the domain name, no demonstrable preparation to use the domain name. But when coming to the bad faith part, they only lacked at one small part, that is registration in bad faith. Only because they were unable to prove that it was a registration in bad faith. That also happened because they did not produce the evidence from the year that was earlier to the trademark registration. If they had provided more evidence as to the sales, or they were already well known in the initial period, Though I remember there was one annexure, some news clipping that related to a day before the domain name was registered, but I don't remember that they even argued for once in their complaint that see this day there was a news clipping and the next day the domain name was registered. And even there was some more discrepancy in the whois information. If some research was made and those points were very clearly made out before the panelists, they could have won. And it was more importantly, it was just few months before their IPO was supposed to come. So it was really a good strategy on their part that they come under UDRP. But later, still after this decision, even instead of having some settlement with the owner, they are still trying to get this domain name through by filing a matter before a high court in Chennai. And though they may get it because it's going to be an ex parte, as the respondent is based in Australia and he hasn't come to defend the matter. But it would have been, I think Vivek also agrees that it would have been better if the parties would have settled the matter.
I think it shows a kind of lacking confidence or foresight in the company to not acquire the domain name kalyanjewellers.com. First of all, I think any big brand that is going out in the market, especially if you're a B2C brand with such a huge physical presence, you absolutely must own the correct set of domains so that you do not have to face challenges such as this. Secondly, if you are going for a UDRP, please don't take it lightly, because the panelists that might be assigned to you might not belong to the country. The panelists might not have ever heard of Kalyan Jewellers. The panelists might not know who is Amitabh Bachchan. So you need to make a very watertight case and put in all the effort and due diligence into it to make sure that you're putting all the facts right and enough to convince the panelists that you are a huge brand, that you are well known, and you have been there for a very long time in the market and are well known. So even if you think that all the three tenets you are satisfying easily, please don't take it lightly. Always remember the case of Kalyan Jewellers. They are still fighting the case, trying to get the domain back, wherein they could have easily settled for it, or they actually should have acquired a lot of domains earlier in their business when they were setting up. So sadly, Kalyan Jewellers now sits on kalyanjewellers.net. Right? Again, it's a learning for all of us. So before we move on to question answer rounds, I hope everybody has entered their questions in chat or are ready to ask their questions. I'll just cover this very quickly. To DND or not to DND, to plagiarize from Shakespeare, you have to realize that a domain name dispute is not a long-term abuse mitigation mechanism. If you have hundreds of fake websites running on your ruining your trademark, if you constantly come across domains that are using your trademark or your branding and creating fake websites, or registering domain names and sending out lots of emails, then you should look at some other solutions in looking at other techno-legal solutions to shut down these websites quickly. Because one thing that happens with a successful UDRP is that domain is transferred over to you. So then you need to make sure that you are in a position to accept that domain name and keep renewing that domain name year after year after year. Recently, a case was filed by WhatsApp Meta company, wherein they had filed a UDRP with 154 domain names in one complaint because all of them were registered by the same owner. Now that they have acquired those domain names, they have to keep renewing those domain names year after year after year. That's nothing less than 1 lakh rupees every year to register these domains, which they will never use. So if you are filing a UDRP, please have a process in place as to once you win the UDRP, what will you do with that domain? I have seen multiple cases where businesses win the UDRP and the domain is still lying with the lawyer who actually represented you. There was no plan to use the domain post the win. Either they did not have confidence in the win, or they did not have the foresight to figure out what we will do with this domain once you win. So as they say, there are two big tragedies in life: not getting what you want and getting what you want. So even after you get what you want, you need to figure out how you will manage this digital asset. And in case if you have made any prior attempts to acquire the domain name, please make sure you clearly state that in your complaint. If you have tried to acquire the domain name and you could not agree on a price, then you will surely fail in a UDRP. So before you take either decision, be very sure as to what is the reason why you are going for a UDRP. If you want to own that domain but you don't think you have legitimate rights, it might be better to try and buy that domain name. If you have tried to buy that domain name, then going for a UDRP might not be in your best interest. The challenge becomes that if you try to buy the UDRP and you actually failed in the if you try to buy the domain name and then you try to file a UDRP in which you again failed, then there is no way you will be able to get the price down of the domain name from the domain seller, because there is no threat to the domain seller, right? And we all know how long legal challenges and legal processes take. So be very careful as to when you want to file a UDRP and why you want to file a UDRP or INDRP or any other domain name dispute process. As part of the webinar, after we conclude with the webinar, we will send you a recording of the webinar, the presentation that we have used, and we'll also send you a quick evaluation checklist, which will cover the 3 tenets that we have discussed here, common pitfalls that generally plague a lot of complainants, the different DND forums that are out there, like WIPO, National Arbitration Forum. There are a couple of them in Asia as well. What is the process of DND mechanism? When you should file it? How long does it take? Where you should go and file it? The pricing and all, and links to some useful resources across the web that you can utilize to further strengthen your own cases or learn more about this process. So with that, I'll open the floor for question and answers. So if you have a question, you can put it in the chat, or if you would like to ask the question, you can unmute yourself and ask the question directly. Vinay, can you please read out the question?
Yeah, there's already a question. I'll read it out for Ankur. The question is, does Dream Law In and Dream Legal In possess similarities if Dream Law has a trademark and is a prior user? Can Dream Legal continue its activities without registration for trademark, as both of them are working under class 41?
Okay. Okay, Ankur, that's some legal advice that is requested from you live. If you want to take this now, or if you would like more details about it, you can ask this.
Yeah. So I suppose yes, similarity would be there if someone has already registered a mark and is a prior user, then of course the risk would be there. So any use could be, there could be risk of an INDRP or otherwise an injunction from the court regarding the use of the domain name. Though it can be, defense can be given that the words are quite common. So in such matter, it's better to avoid any such use, because even if some defense is there that you are not aware of the other one, but then in such matters, always it depends upon the pressure or power you can see from the other side. If it's a big law firm, they may try to pressurize you. So it's always better that when you register any kind of domain name, you do some due diligence that any similar domain name or similar trademark is not there on the record, because it's always better to be safe, because you are just naming your startup or your company, so you always have alternative options. So it's better to avoid it rather than be in some legal hassles later.
Sure. Thanks, Ankur. I have one question, Ankur, which if you would please answer. If somebody loses a INDRP or a URS case with WIPO or the Indian Arbitration Authority, what are the redressals do they have? Can they go to higher court, or what should they be? What can they do?
Yeah, under INDRP, the system is still simpler because it is in terms of the Arbitration and Conciliation Act 1996. So according to the provision, after you receive a copy of the decision, that is the date on which it is published, you get 90 days time period to file any kind of appeal that can mostly happen under Section 34 or the Arbitration Act before a high court. So mainly, as Nixie is located in New Delhi, so the jurisdiction of Delhi High Court can very easily be made out. So it's quite simple, and the time period is quite flexible. 90 days is good enough. But when it comes to UDRP, there are many challenges. First is jurisdiction, and second is time period. Now suppose today is 18th. Today I get a UDRP decision that goes in the favor of the trademark owner, and the domain owner wants that before the domain name gets transferred, he needs to get an injunction from the court. So the domain owner only has 10 working days from today. So if the jurisdiction firstly, the jurisdiction will depend upon the place of business of the registrar, domain registrar. Because in the UDRP complaint, an option is provided to the trademark owner to select a jurisdiction, which can be either of the two. It could be the place where the domain owner resides, and the trademark owner will never select that jurisdiction. And second is always the place of business where the address of domain registrar is. So mostly the trademark owner select this second option because it becomes quite difficult for a domain owner to go in the jurisdiction. Now suppose the domain registrar is GoDaddy. Then the GoDaddy's principal place of business is Arizona, USA. Now if you want to take an injunction against the decision, then you need within 10 days time, you need to file the the injunction against the UDRP decision in USA. So it is not only practically difficulty is there, but it's quite expensive. A lawyer will there start minimum with, for any case matter, $10,000 would be quoted to you. That is the upfront payment. So, or suppose taking a second example, if the domain name is kept at Big Rock, say the jurisdiction is in Mumbai, so still in that case, it is possible that you may, through some Mumbai lawyer, you can get an injunction filed in Mumbai within the 10 days time. So the excluding the Sundays, 10 working days will be counted, within which you need to show to the UDRP, see these are the documents, acknowledgement from the court, and we have already filed the matter. So the no transfer of the domain name should take place. So this is how it works.
If I might just add to that for the benefit of everybody here. So the process works in this way. The moment somebody files a UDRP against a domain name, the domain name is locked. So the WIPO, once they accept the complaint, they inform the registrar to lock the domain so that you cannot transfer the domain during the process. You cannot transfer the domain, you cannot make any changes to the settings of the domain, you cannot make any changes in the domain. It is locked and it will stay locked till the decision is delivered. Now, if the decision is delivered in the favor of the domain owner, the domain is unlocked, you are free to go about your business as it is, and the complainant or the trademark owner can go and file case in some in another legal process. But if the results are against the domain owner, then as soon as the decision is delivered, like Ankur said, after 10 working days, the domain will automatically be transferred to the trademark owner or the complainant. The domain owner can do nothing to prevent this transfer other than get an injunction based on what Ankur just informed you. Case in point, there was a domain called France.com. It was owned by a person, an individual, who used to own that domain and run a website to promote tourism in France. He even worked with a lot of French embassies in different countries to highlight the tourism opportunities and the places of France. One day, the French government decided they should own that domain. They filed a case, they won that case, and the domain was taken from the person who has owned it and ran and used that domain for multiple years and simply given to the French government. So what Ankur said is very relevant, that you should be very clear who is the registrar of your domain. Even I had that question, that suppose my domain is with GoDaddy. GoDaddy has a presence in India. They are registered in India. They have GST in India. But GoDaddy's principal place of business is Arizona. So if you have a domain sitting on GoDaddy and you lose a UDRP, you better catch a flight very quickly or find somebody in Arizona to file a case to prevent the domain transfer. So these are the nitty-gritties that people in the business know about. They can support you with this. They can inform you the right way of making sure that this does not happen to you. Any more questions? Please feel free to unmute yourself and ask a question. Okay, if there are no more questions, and I think we still have few minutes, Ankur, maybe you can cover the tickets.in.
Yes, sure. So in this matter, I was not representing this matter, rather I was an arbitrator in this matter. It was represented from the respondent side by a scriboard firm, that is Mr. Rodney Ryder. So in this matter, what happened was this trademark owner came into INDRP. They claimed that we are into business since the year 1998 when their .co.uk domain name was registered. And they also claimed that they were already using tickets.org.in from the year 2006, and also made some few more claims as to the usage of their mark for the last many years. So here what happened was, this domain name, as you can see from the screenshot, it was not in use, but it had registration date of 16 Feb 2005. That is the date on which the domain names were launched by Nixie. That is, .in domain names were launched on 16 Feb 2005. So this domain name was not using a domain name in any manner. But the main issue here was that the trademark registrations of this company in India were recent ones again. I think they related to around the year 2013 or later. And through web archives, it was very much evident that no use of this domain name or the tickets mark has ever been made by this company earlier to 2013. Neither their main website ttm.org was active, neither tickets.co.uk was active before 2013, neither tickets.org.in was active. So a little more search as a panelist by myself, it came into my knowledge that these domain names were sold in the year 2013. They exchanged hands. So that evidence was presented to the complainant party to provide any arguments in support that how these domain names were sold in 2013 if you are already holding them since the date of registration in 2006. So with that, which they failed to satisfy. So it was held as a matter of reverse domain hijacking, because the complainant here tries to misrepresent that they are making the use of their mark since 2006. Firstly, the domain name already had a prior registration, and secondly, still they were using it from 2013 but claiming it from 2006. And for that purpose, they had some changes made to the trademark registry records as well to show the usage from 2006 based upon only this date of registration of their tickets.org.in domain name. So they were really trying to manipulate things. So that's why this rare RDNH was passed by me as a panelist.
Vivek, we can't hear you. You're mute.
Thank you, Ankur. That was very interesting. And like you mentioned, you were the panelist in that case. And wasn't it one of the longest results ever written in the case of INDRP?
No, this was not that much longer, but there's another matter, newshunt.in, that runs into 150, with an extra that runs into 150 pages. That is the longest one that I had written.
Great.
Your volunteer.
So please, for all the attendees, I request you please make sure that you have a valid email address that you used when registering. If you would like to provide another email address to receive the recording for the webinar, the presentation, as well as the UDRP evaluation checklist, please put your email address in the chat here so that we'll ensure that you get all these details in your email box. With that, I'll request if there are more questions, we can take them. We still have 2 more minutes to go. If not, then I will conclude the webinar. If you have come across any other UDRP complaint or INDRP complaint that you would like to know more about, you can put in. If we have information, we can share now. Or if you have other cases of domain abuse or brand abuse that you have come across, please feel free to share with us. We'll be more than happy to come back to you and inform you of what are the options that you have. Because like I said, UDRP should not be taken lightly. There are other techno-legal solutions that are available for brands to shut down fake websites. We do it on a regular basis. About hundreds of websites we shut down on a daily basis. And you can use those methodologies and those processes to bring immediate relief to the brand. 1 more minute, quick update. For those of you who work in the domain space or represent brands who work in international markets, .com.au, which is the CCTLD for Australia, has changed some policies. So now you can register domain names directly under .au. Earlier it has to be .co.au, but now you can register them directly under .au, which is going to open on the 22nd of March. So if you represent brands or if you work with brands who work in Australia or planning to go into Australia, this is a very important time to register the right domain. So registering domains is very important. Even before you file a trademark, you should acquire the right domain, as Kalyan Jewellers should have done when they started the business. So we are right on the dot. It's 4 o'clock. I don't see any hands up. Any questions? Anybody would like to ask? Okay. Thank you, Vishwas. And other attendees, we hope you enjoyed it too and learned something from the session. So thank you, Ankur, very much for coming and giving us your valuable information and your valuable time. Let's see if we can arrange another webinar and explain in detail more about INDRP or URS. URS is a little less well known, so we can inform attendees about URS and when to do URS and what to do. So thank you everyone for joining. Vinay, we can end the session now. Thank you everyone. Have a good day. Bye-bye.
Thank you.